the implications of private creditors seeking reinforcement or enforcing the public debts of poor countries has been a very big issue. The specificity of the legislation is highly reflective of the characters and the issues traditionally involved. As the name indicates, the legislation is called the Debt Relief and Vulture Funds, or the Developing Countries Act of 2010. What it does essentially is it protects, to a specified threshold, the public debt of 40 countries in the World Bank and International Monetary Fund's Heavily Indebted Poor Countries Initiative, or the HIPC. Protects from whom, you may ask? Well, I'm going to ask the question, I'm going to answer the question. Of course, this is from the vulture funds. The correlation between vulture funds and holdout creditors is something that I'll get to later on. But to begin the story, I start with this main character in the story that I'm about to reveal. My presentation to you, of course, today centers on some of the original issues and players involved with the American play on what has evolved into U.S. holdout litigation. To coincide with Emily's portion of the presentation, I will walk through the inception of the U.S. history with private creditors, or private investors, collecting payments on bonds from defaulted sovereign debts under U.S. law. This will ultimately lead me towards introducing the legal reconstruction of the sovereign lending market as it is today, and how it's invited the contemporary form of what we now consider, or we now have more information about towards the holdout creditor, which at sometimes doubles as a vulture fund. To begin, in my introduction, I used the word species to qualify the type of investor that deserve the special attention from the UK Parliament. Of course, the term vulture fund, in English, a vulture is a bird of prey that seeks on the weak and the feeble. Despite the UK's initiative, however, the United States, as perhaps the largest jurisdiction to invite sovereign bond claims against poor countries, has yet to adopt a similar legislation. This is interesting simply because of the fact that the UK legislation, or the UK as another very big capital market, has taken very forthcoming steps in preventing something that is morally reprehensible, but legally quite permitted. So the jungling, or I would say the commingling of morals, political ramifications, and legal implications in this subset of what we call the sovereign bond market and sovereign bond litigation becomes very interesting, and it's a real mix of all these different interdisciplinary concepts. I'm going to try to stick with the legal concepts as best I can. To date, the U.S. courts continue to abide by a decision that was dated in 1985. In the last of the three cases between Allied Bank International and the government of Costa Rica, decided almost 30 years ago to date, the United States Second Circuit Court of Appeals elevated securing private creditors' rights over safeguarding sovereign interests in private contractual relationships. Put differently, the appeals court upheld the private creditors' rights to sue and seize assets from weak and feeble and even very poor countries. Of course, the inception of the U.S. holdout litigation was not characteristic of this opportunism and sympathetic patrimony for poor countries. The background behind my presentation was a paper that I wrote, which was to sort of flesh out the legal details as to the political arguments that are being laid out for vulture funds and their attacks, so to speak, on poor countries. Of course, as a lawyer, I've been trained to be a lot more impartial and to not fall prey or fall victim to the, I would say, the patronizing arguments that somehow come to be. So in my reflection and in my review, I tried to really seek out and try to keep focused on the legal implications and the legal law as it was applied, of course, under the U.S. Courts. That said, the original conflicts that existed arose between sovereign borrowers, large banks as lenders, and abject legal confusion as to whether the public nature of the borrowing state required limitations on the application of private law. Of course, as you know and as you will find out in more detail, based on the Allied Bank decision, the private law won. The legal ramifications of Allied Bank's lending relationship with Costa Rica began on July 8, 1983. The issue of the extent to which private contract law will protect the reasonable interests of commercial parties when one party is in fact a sovereign state first arose in New York's Southern District in the form of Costa Rica's government setting out to defend halting its foreign debt payments pending a resolution to its economic crisis. Now, all of us here are very familiar with the state of affairs in underdeveloped countries. The protections that they receive from public or international institutions such as the World Bank and the IMF do not necessarily translate cleanly into strict jurisdictions. So of course, the UK passing the legislation does not necessarily inform legislation or the treatment of these developed countries in the US or Canada for that matter. As a brief background, however, between 1980 and 1982, Costa Rica experienced an offsetting period of unprecedented hyperinflation and explosive unemployment. Real GDP declined by 9.2%, and unemployment nearly doubled from 4.8% to 9.4%. Inflation, I read this and my eyes almost popped out. Inflation swelled to 157.6%. Real wages and real capital consumption dropped with equal gravity by at least 30%. Foreign debt, a key component of the country's fiscal portfolio, skyrocketed to a US $4 billion. The suspension of the payment of the debts to the Allied Bank Consortium naturally interrupted the payments. In response to the government's decree to force Costa Rica to comply with its lending agreement, Allied Bank and its lending consortium filed a claim in New York City's Southern District, alleging a strict breach of contract claim. In the first of a series of opinions, Judge Thomas Griesa of the Southern District Court of New York declined to grant Allied's claim on grounds that a judgment in favor of Allied, in this case, would constitute a judicial determination that defendants must make payments contrary to the directives of their government. This puts the judicial branch of the United States at odds with policies laid down by a foreign government on an issue deemed by that government to be of central importance. Such an act by this court risks embarrassment to the relations between the executive branch of the United States and the government of Costa Rica. This was Judge Griesa's forced entry into the issues that deal with holdout creditors, vulture funds, and indebted countries. Anybody who's familiar with the literature and of course of the commentaries and the written articles and papers about the contemporary sovereign bond issues, and in particular Argentina, have heard the name Judge Griesa. The issues here were first introduced to him in 1983, and he's still dealing with the same issues on cases that have lasted 20 plus years. Needless to say, he's gotten better at dealing with these cases. But in the beginning, it was very touch and go. Just to continue. In addition to Judge Griesa's decision, the United States executive branch entered the fray by signing the Paris Club Agreed Minute. For those of you who may not be aware, the Paris Club is an informal group of official public debtors, mainly from the world's largest economies, which provide debt restructuring, debt relief, and debt cancellation to indebted countries and their creditors. The private creditor counterpart is known as the London Club. The Paris Club Agreed Minute, in this case, advocated for rescheduling Costa Rica's intergovernmental and commercial debts. The U.S. House of Representatives also endorsed full support for the Republic of Costa Rica and its democratic institutions as it responds to the current economic crisis. Small background to this, which steps outside of the legal picture, is the history between the U.S. and Costa Rica was a very defined one by the fact that they combined together to wage a defensive war, I would call, of sorts, against Nicaragua and the Sandinista government. So the political relationship that held the two countries together was something that was used to supersede the laws that were applied later on in the cases. This essentially was the turmoil or the division or the divide that made the Allied case such a prominent case and such a obviously long-standing case that exists today. In light of the circumstances, Allied Bank continued. So in the end, after Judge Griesa's first decision, of course, the case was decided in favor of Costa Rica. In light of the circumstances, Allied Bank, of course, petitioned its case to the Second Circuit Court of Appeals. Once again, however, in light of the political relationship between Costa Rica and the United States, the second case between Allied and Costa Rica was held in the nation state's favor once again. The court in this case, which now is the appeal court, the higher court, wrote, Costa Rica's renegotiation of its debts is consistent with our foreign policy as indicated by the support voiced for the renegotiation by both the legislative and the executive branches of our government. Because the decree and the resolutions of the Costa Rican government that resulted in Apeli's default were consistent with the law and policy of the United States, their validity should be recognized in United States courts. Of course, in the United States, you have a very big lobby in different avenues and different facets of economic and political life. In this case, the Wall Street lobby entered the forum. They carry a heavy fist with heavy pockets. And needless to say, the outcome, the decision that later established what is now the law towards sovereign bond litigation in the United States was essentially promoted by the Wall Street lobby. Following decision, the Wall Street lobby, or Wall Street financial institutions more or less, forced the US Senate to debate the problem with supporting Costa Rica. To quickly fast forward past the legal melee that ensued, a final reversal of its previous decision led the appeals court to establish the existing policy on sovereign debt litigation today. Accordingly, as it stands, regardless of the executive branch's foreign relation with a foreign government, while parties may agree to renegotiate conditions of payment, the underlying obligations to pay nevertheless remain valid and enforceable. Simply put, the United States does not endorse unilateral abrogation of private loan contracts by debtor nations. This, of course, stands in stark contrast to the UK. In the UK's case, there is currently an organization, and it's an international organization split up in different jurisdictions, known as the Jubilee 2000. And the Jubilee 2000 has a mandate, or has sort of developed a mission to ensure, in the best case, the eliminating debts from poor countries. Pardon the pause. Towards that goal, of course, the UK legislation was something that goes towards helping that, with having an eye towards debt rescheduling and debt restructuring. Of course, the end goal is in view, but slow but sure. The Jubilee 2000 organization is working towards also lobbying the US and other major jurisdictions that do invite this kind of litigation. Coming back to the Allied Bank case. Following the Allied decision, the problem with defaulting debtors and the US bank grew increasingly more troublesome. To keep the legal and political issues separate, under an early program introduced by Treasury Secretary James Baker, the US introduced the Program for Sustained Growth. This was in 1985. Under it, sovereign debtors were guaranteed continual funding if they only adopted US suggested trade policies. The understanding, or the principal understanding under the Baker plan, was simply that the countries that were in debt or were defaulting on their debts had faulty political and economic policies. What the US was trying to do was in essence to translate their understanding of how to run a government and how to run an economy overseas. Of course, this doesn't take well with other nation states. Of course, sovereignty between nations is something that is heavily guarded, and of course, for one country to impose its will on another country doesn't sit well with the recipient. So, of course, the plan ultimately failed and introduced what today exists in financial markets as Brady bonds. With that said, vulture funds and holdout creditors were also introduced. Under the first Bush administration, Treasury Secretary Nicholas F. Brady devised a plan. His plan was essentially to have U.S. commercial banks accept an orderly process of debt reduction. Subsequently, international financial institutions like the IMF would then set their respective lending policies to facilitate the process. This is, of course, very in stark contrast to the James Baker plan in many ways, but in the most definitive way, it was different in the fact that the IMF and the World Bank, these international institutions, were on board. In the other case, it was strictly a U.S. initiated program that was attempted to help reschedule and renegotiate and even eliminate some of the debts from these sovereign nations, other sovereign nations. Under the Brady Plan, to qualify, U.S. commercial banks were required to forgive portions of their sovereign loans in return for the U.S. government's guarantee to pay the balance. In addition, debtor nations were asked to implement a brand of sound economic policymaking to support and promote new, less debt-intensive capital initiatives. Ultimately, Brady's plan would in fact move banks closer to recovery and likely promote the flow of new money back into developing countries. The specifics under the plan are very particular. However, in a broad overview, outstanding bank loans were converted into newly minted Brady bonds. These Brady bonds were pooled and repackaged as 30-year bullet bonds with principals due on one payment after 30 years. The sovereign bonds were backed by U.S. zero-coupon treasury bonds that secured their principal along with 12 to 18 months interest. The U.S. Treasury bonds were then purchased by the sovereign debtors with financing that they received from multilateral institutions such as the World Bank. With the proceeds being directed towards paying down the balance, the Brady bond was priced and sold in the secondary debt market. By design, of course, leading into the conversation of holdout creditors as it stands today, key terms governing the Brady bonds were left largely to the parties themselves to negotiate. Also, Brady's plan provided that an exchange could be effected only upon the consent of a critical mass of creditors. Notably missing from the bond drafting was that the bonds did not include majority acceleration clauses or other devices which might serve to discourage litigation in the face of default or agreed restructuring. I'm sure you'll get more of that information in Emily's presentation. The introduction of the Brady bond and the secondary market followed what was originally a private lending market. Before sovereign bonds were introduced, banks were large international banks in particular, were the ones who lend money to countries. Large international banks like Citibanks typically held the largest stakes in outstanding sovereign bank loans. Hence, when a country missed paying interest on a respective loan, Citibank, as the bank with the greater interest in the transaction, for example, would generally handle drafting new payment terms and spearhead negotiations with the troubled sovereign debtor and all the other members of the banking consortium that were involved in lending the money to the sovereign entity. The smaller banks, of course, who may not have had the same pecuniary interest as the larger banks like Citibank, had very little say at the table. However, their say was very vital into the renegotiation or rescheduling of the debts. In essence, although they were usually resigned to ratifying deals, from the sidelines, they were instrumental in solidifying the renegotiation of these structured deals. That said, to earn their approval on tentative payments agreements, the larger banks worked extensively with these other banks, both large and small, in order to reach an agreement. In essence, what I'm saying is the sovereign bond or the public lending market at the time was very small and it was very private. It was essentially between sophisticated lenders to state entities. The issues that will be fleshed out later on, perhaps in Emily's presentation, a little bit in my presentation, is that the difference is today we have the difference between institutional investors and retail investors. And their goals and their missions and their aims are very different and in a lot of cases in stark contrast to each other. To harken back to my presentation, the leading international banks shared the risks of sovereign lending through syndication. And when problems arose, they sat together on creditor committees. They also provided a range of financial services to each other and to smaller banks. These financial relationships permitted both reciprocity and retaliation and facilitated policy coordination. In the end, these working relationships fostered enough cooperation amongst banks to quickly resolve debtor liquidity problems. Litigation, like in the Allied Bank case, was seldom considered. Of course, the situation is much different today. Today, when dealing with a missed sovereign bond payment, large institutional investors may be willing to overlook the payment and suffer a greater loss in a restructuring plan in order to solidify a relationship with the sovereign debtor. Of course, this leads to continued business down the road. Retail investors, on the other hand, are more or less in for the one-time gain or the one transaction. Therefore, their long-term goal does not exist. In this situation, of course, there is no business relationship and there is no aim in order to facilitate or to assist the sovereign debtor who may be in very deep trouble come out of that trouble in order for a better gain in the long run, for a better agreement, or perhaps a mutual agreement to benefit both parties. To come full circle, this evolution and diversity between sovereign bondholders has introduced the emergence of vulture funds. The vulture funds that I've mentioned in the beginning, the vulture funds that have been the object of petition by the Jubilee 2000 organization, which have also been enshrined in the UK Parliament's Debt Reconsideration Act of 2010, and has also been, of course, in papers and just amongst several different organizations, individuals, Bono, all of these people that we know deal with the debt issues that a lot of these poor, highly indebted sovereign nations are faced with on a regular basis. I think the difference now between what has come to pass with the Allied Bank decision and Costa Rica is the fact that today, in stark contrast to Costa Rica, countries that are not so poor, such as Argentina, are now dealing with cases where they're dealing with sovereign debtors and holdout litigation. And the play and the political background behind this situation is much different than it would be, or it was in the Allied Bank situation. That said, regardless, the law in the US still stands as it is today, that the private rights supersede public interests for indebted countries, and there doesn't seem to be any indication that it will change anytime soon. Thank you.
All right, well, I'm going to leave off then, more or less where Harvey has left us. Unfortunately, I don't have a Canadian court decision to criticize, which would have been my aim had there been any sovereign debt issues coming out of Canadian courts. All right. That said, I will be taking something more of a theoretical perspective on this. I'm not going to look specifically at a court decision or specifically at the investment arbitrations, the Abelklats, that will come up in the discussion. But what I'm looking at is more of a theoretical perspective on this. Are there certain obligations, what are rather the limits of the rights of holdout creditors within the international sphere? Are there international aspects of international law that limit how much and what the holdout creditors can actually do, and whether or not they can, in fact, hold out? All right, so Harvey has touched on much of this, but of course, we're dealing with this issue of restructuring, right? Sovereign bonds, the country can't pay them back, so they're restructured. Now, of course, this wasn't always the way that bond issues were dealt with. And the reason that I bring this up at this phase is because what's happening when we look later on in terms of how restructuring is dealt with, it's important because it's a very much changing system. So the idea is now we don't use military pressure anymore to make sure that these bonds are repaid. As wonderful as it sounds to have your, whatever your home country is, go to the debtor country with lots of military weapons. Of course, this would be more of a US action than a Canadian action anyways, once again. This isn't how it's dealt with today, right? Harvey noted the idea of linking debt with trade in some aspects, but of course restructuring is where this takes us, particularly with regard to these crises after the 1980s. During the 1980s, the Baker Plan, the Brady Plan, and how that has then become the more recognized way to deal with sovereign bond issues. And with regard to this idea of restructuring, this is, of course, the Abuklat decision. Now, this was just the jurisdictional decision, and this is important to note that it's the jurisdictional decision and not the decision on the merits yet, which takes us to the next aspect of what we're going to be talking about. But the court noted that there exists no formal legal framework establishing the precise steps to be taken. Nevertheless, there is an informal regime that has developed, consisting of the following principles. The sovereign signals the need to restructure the debt, communication between the sovereign and the creditors, consensus and consent on the terms of the restructure, and then equitable debt burden sharing. So this is the way that it's generally been recognized now that this structuring takes place, at least according to this investment tribunal. Now, of course, that's up for debate in terms of whether or not that is how it's consistently applied. But this is generally the idea of how the restructuring itself takes place. Notably, point 4, the equitable burden sharing aspect of that, and how much that does actually follow through in terms of how the restructuring takes place. All right, holdout creditors. I think Harvey more or less has dealt with this, but just to give you a refresher as it is now that you're all halfway experts on this topic, these are basically sovereign bondholders who've decided not to accept whatever that government's restructuring plan is. All right, so they've decided that, okay, we recognize that this sovereign can't necessarily pay our bonds back the way that we want them to be paid. But on the other hand, we have this private contract, which Harvey has referred to, and this private contract does give us this right to ensure that we will be repaid, and repaid in full. And that's where the Argentina problem comes in, of course. Right, so the 100 billion in sovereign debt that was defaulted on. Now, the restructuring plan in 2005 offered the equivalent of 33 cents for every dollar. So, if we think about this concept of holdout creditors, there is a potential logic behind it. So, if they're only going to get 33 cents on every dollar that they had anticipated getting, perhaps there's value in them not accepting what those offers are. Now, in 93% though of creditors did actually accept in both 2005. After 2005, there was legislation that was passed that said that the government of Argentina would simply not reopen the restructuring. So it was meant as a way to encourage creditors to accept that restructuring. Nonetheless, in 2010, they did, of course, offer another restructuring plan. But there still remains, of course, a few holdout creditors, and these are the cases that you hear about coming out of the US, Italy, and Germany, in addition to this investment tribunal. So a few holdout creditors, of course, not accepting this 33 cents on the dollar. All right, so where have holdout creditors sought enforcement? Now, I put FTAs on there, but this is increasingly excluded from the scope of protections provided in most of these agreements for creditors to be able to seek enforcement under a free trade agreement. This is, of course, where Abuklat takes us. And in the Abuklat decision, it's quite important that it needed to fit into the definition of investment under both the bilateral treaty and according to ICSID. Of course, the tribunal rather did assume jurisdiction in Abuklat. We don't have a decision yet, but they did assume jurisdiction. And part of the reason for that is they recognize that it is a contractual claim. Right? These bonds are contracts between the government and the creditor. But on the other hand, the actions that the government of Argentina took following the default was derived from Argentina's exercise of sovereign power. Therefore, as such, they were able to bring it into the definition of investment under the relevant treaties in that context. Now, of course, the Abuklat decision is more interesting in light of investment arbitration, in the sense that there were a large number of bondholders, of holdout creditors that brought the dispute to the investment tribunal. But on the other hand, also important for allowing these sovereign bond issues to come under the definition of investment. All right, and then of course local courts, US, Germany, Italy, where these local court issues have come out. All right, so ultimately the question, though, to be answered today, and the question to be considered by tribunals, by courts, as we see these sovereign bond issues going further, is whether or not there is an obligation in international law for these creditors to participate in the restructuring plan. Right, now I already said that only 93% of creditors did participate in the 2005-2010 restructurings of the Argentina sovereign bonds. But of those 7%, were they required to under international law? Now, I've separated it into three aspects where we can potentially see this requirement for participation to come out of. All right, so the first one is negotiation in good faith. I have to talk about it, it's the dissertation. Collective action clauses. This is the second. This is part of the changing nature of sovereign bonds, how the law behind sovereign bonds. And then the last point is social welfare considerations and how aspects of human rights, this might be interesting for the Moody's, how issues of human rights may actually come out through these obligations arising under international law. All right. So if we look at this from the aspect of investment, generally there is a duty for these creditors as investors to act within the applicable rules of international law. Right now it's of course different than requiring a state to apply and to act within the applicable rules of international law, but nonetheless, as investors, they still have this general duty to negotiate in good faith. Now that might come out in the treaty in a number of different ways, amicable settlement, something like this. Now, the idea is though that restructuring, this initial effort by the state to restructure those sovereign bonds, even if it's 33 cents on every dollar, might be considered a good faith effort on the part of the state to negotiate and to settle prior to that creditor then taking it to a court or to an investment tribunal. Now, of course, the argument from these creditors is that 33 cents on the dollar was simply not a good faith effort to negotiate. Perhaps that's for all of you to decide. If you lend out money to a friend and they decide to only give you 33 cents back. Nonetheless, the idea is it can go both ways, right? So it was a good faith effort potentially by the states, and potentially that may not be considered a good faith effort by the creditors. And that is, of course, the inherent problem with this idea of the basic requirement to negotiate in good faith. It's something of a subjective standard, if you will, whether or not a tribunal would in fact decide to decline jurisdiction based on the restructuring plan that had been submitted. It's difficult to say, but unlikely that this good faith criteria would be considered as sufficient in that regard. Now, it is important, though, this idea of good faith negotiation does come out in Principle 7 of the UNCTAD Principles on Responsible Sovereign Lending and Borrowing. Now, this gets us into a much bigger conversation on whether or not this does represent and has reached the status of customary international law and how things should be applied. But in circumstances where a sovereign is manifestly unable To service its debts, all lenders have a duty to behave in good faith and with cooperative spirit. Once again, though, we have very subjective obligations there that may be applied differently in different contexts. All right, so good faith, obligation to negotiate in good faith is the first of my potential submissions in why a holdout creditor may or may not have to participate in the restructuring. All right, so you can imagine situations, of course, where this might come in if it is, but once again, rather subjective in its application. All right, so the next aspect is collective action clauses. All right, so this is the idea that if a majority, usually it's 67%, 70% of the creditors agree to a specific restructuring plan, then all of the creditors are required to accept that plan. Now, what's interesting about these collective action clauses is that they do have quite a long history under English law. But they are somewhat more recent, yes, more recent, in New York law since 2002. What's important, though, is since 2002, they are almost entirely, consistently used in sovereign bond, the law on sovereign bonds, or the language of the sovereign bond. Why English law and New York law matter? These are typically the laws relevant to sovereign bonds. So this is where it becomes important. So if you look at the bonds that have been issued, for example, in Argentina, for example, since 2005, it's all under New York law. This is how things are done. So the increasing use and the prevalence of collective action clauses within both English law and New York law is demonstrating that it is becoming the accepted form of it. It's become close to 100% of the new bonds issued. Now, of course, this becomes problematic because most of these sovereign bond issues, these repayment issues, are dealing with older bonds. But the idea is, has this widespread use of the collective action clauses reached the threshold of state practice? If we look at it under the statute of the ICJ, is this sufficient? And is this, more importantly, sufficient for us to apply it to these older bonds? Can you also then require that the states similarly, or the creditors rather, similarly accept that this has now become state practice, therefore they need to accept whatever the majority of the other bondholders have accepted as part of their restructuring. All right, and so the final of the potential aspects under international law that may require holdout creditors to participate in the restructuring plan are these social welfare and debt payment considerations. Harvey mentioned this in the context of the heavily indebted poor country initiative. And of course, problematic when we look at it from the Argentina perspective. It's not necessarily considered one of these underdeveloped countries that might fit into this. Nonetheless, it is still recognized that there's a high priority given to the well-being of a state and the sustainability, rather, of human development within that state. That every state has this primary responsibility to promote the economic, social, and cultural development of its people. Now, the idea coming out of this is if repaying these sovereign bonds is simply taking away from a state's ability to properly provide for its population, has it then reached this threshold of being a violation of basic social welfare, human rights standards, thus creating a situation that those creditors should have been obliged to participate in that restructuring plan. So this in part comes out of a human rights resolution. And then also guiding principles on foreign debt. Principle 8, providing that any foreign debt strategy must be designed not to hamper the improvement of conditions guaranteeing the enjoyment of human rights and must be directed inter alia to ensuring the debtor states achieve an adequate level of growth to meet their social and economic needs and their development requirements, as well as their human rights obligations. So, theoretically, if we had a situation where you could pinpoint human rights obligations simply not being fulfilled because of these debt obligations, potentially we could see something coming out of this third idea of obligations to participate based on social welfare considerations. All right, so the conclusions that come out of this, perhaps holdout creditors need to be a bit more cautious when deciding to, in fact, hold out. Recognizing that there is potentially changing obligations arising under international law, particularly with regard to these collective action clauses, whether or not this puts obligations on the non-majority creditors in their consideration of the repayment schedules, and then finally the perhaps obligation, if it is, for tribunals and courts to also consider these additional obligations, and as a way of ensuring that there is this maintained financial stability despite the potential of a holdout creditor, and of course the potential for a holdout creditor to inhibit the entire restructuring process. So I will finish there and leave you a bit of time for questions.